adjustment of status with DACA applicants, adjustment of status with TPS holders. In this video, we are going to do two cases, okay? We're gonna work on two cases, different type of status, but both cases applicant will want to see if they can adjust status or if they can cancel processing, like go outside and get their immigrant visa from outside. Well, when it comes to employment, we're limiting this video on employment base alone because that was the question, right? When it comes to employment base, the general rule is this, right? If you have accrued unlawful presence for more than 6 months, unfortunately, you cannot adjust status. That's just period, right? Then we go to the exceptions. Do you have 245I? Or do you qualify under technical reasons? 245I, we have explained it in detail. Simply means that you have some type of old petition, either it's a I-130, I-140, or labor certification for employment. Old petition that was approved or approvable at the time it was filed, cutoff date is April 30, 2001, okay? That's the cutoff date. Can be filed or was approvable when filed prior to that date, but just know that the cutoff date is April 30th, 2001. If you have that, then it doesn't matter if you have accrued unlawful presence, then you can adjust status, right, using 245I. If you do not have that, then you go to the second exception, which is so debatable and it just sometimes doesn't work. At least 80% of time it doesn't work. It just depends on the circuit and the reasoning and the facts, right, and the argument itself. So the technical reason says that, well, you failed to maintain lawful presence because it wasn't your fault. For technical reason, an example could be that you have gaps in filing, pretty much changing your status because you submitted your application with USCIS, and then at the time you submitted your application with USCIS, you are still within that non-immigrant lawful status. However, USCIS failed to respond on time. That's why you fell out of status, okay? That's debatable, depending on the facts. If you argue well and you get it right, and then yes, you can adjust status, okay, based on employment. But those two cases that we're going to mention in this video have totally different facts. First case is a DACA applicant. The DACA applicant says that they obtained DACA when they were at least already maybe 19 years old. That's when they got DACA. And later on got advanced parole, and later on travel outside of the United States for some studies abroad and came back, and now they feel like they qualify for employment base because either they have a sponsor or they want to self-sponsor under EB2 category. Well, the same question remains, right? Prior to you acquiring DACA, were you lawfully present on the American soil? If the answer is no, how long? If it's more than 6 months, then we go back to the same reasoning. Do you have an exception under 245I? Do you have an exception under basically technical reasons? If you don't, then we ask another question, because this person has a parent who is a lawful permanent resident. Then the question becomes, can you get a waiver under your parent in terms of unlawful presence waiver by filing the form 601A? Well, the way that one will work is that you file the waiver, okay, and you file it after the employment-based application has been approved, like I-140 petition has been approved. Then you get that approval and you file the waiver with it. And then once the I-601A get approved, then you go outside of the country, first of all, you cover because number one, you have that I-601A waiver approved. Number two, you have advance parole. At least when you go outside of the country, if it doesn't work well for you, you can still come back under advance parole, right? But the reason you're gonna get the immigration visa approved, it's because the I-601A waiver is waiving that unlawful presence prior to you acquiring that VAWA, or that DACA, sorry, that DACA like status. You see how that one is going to play out? Because the person has a parent, so although they do not have a 245I or technical reasons argument, they do have a lawful permanent resident parent, and they are able to apply for an unlawful presence waiver. And on top of it, they have advance parole. So they're going out and do consular processing. That way they'll get the immigrant visa based on employment from outside and then come back with it. You see how this one is going to work? Now the second case study is for TPS holder. This TPS holder is saying that, well, I've talked to 8 lawyers. I have a travel document, because now for TPS, it's no longer advance parole, it's travel document, right? I have a travel document. I am within a lawful status because I have TPS. So now that I'm eligible for employment-based petition, well, why can I not adjust status? My friend, you cannot because of the gap in betweens. Okay, in between, you had more than 6 months of unlawful presence. The travel document, regardless that the fact that you're going to go outside of the country and come back, but when you go to get the immigrant visa petition based on employment at the embassy, the requirements are still the same. Are you admissible to the USA? Well, and then when they look at unlawful presence prior to you acquiring TPS, then the answer is no. Then we go to the exception. Do you qualify under those 2 exceptions, 245I, technical reasons? Then the answer is no, because you do not. Then we go to a parent. Do you have a parent or a spouse who's a lawful permanent resident or you a citizen? If yes, did you file for I-601A? But in your case, the answer is still no, because you don't have a parent who's a lawful permanent resident or a U.S. citizen. So that's why all those 8 lawyers said no. Well, in other words, you can travel outside and come back because you have a travel document. But on the other side, if you are not going to get a visa, like a green card type of visa, approved from outside because of that prior unlawful presence, and it hasn't been cured yet. So pretty much you're stuck. So, and this is different for people who apply for a green card on the family-based qualifying relative, immediate relative. That's a different story. We are focusing for the purpose of this video on employment, and that's the only way it works. So I think this is it, right? We have explained in details, and not to mention, right, that we're only focusing on one inadmissibility issue, which is unlawful presence. What if you have other stuff like entry without inspection, all those things? At least with a travel document or advance parole, you can cure entry without inspection because you can go out and make your second entry, right? But the thing is, unlawful presence, how do you cure that? That's the big question right there in the middle, and that's why a lot of people are stuck. Okay? So chances are, if you just do it the way you feel you can do it, but just trust me, when you go to that consular processing embassy, they're still going to look at inadmissibility issues. Then they're going to tell you that prior unlawful presence hasn't been cured. Unfortunately, we cannot give you that work visa as far as employment base is concerned. So this is how this immigration really works, and it's just so sad, but that's just the way it works. And my friend, this is the detailed type of a consultation that I do with people. So I'm just giving you it here for free and save you a couple dollars, and hopefully something else comes. Then it might allow you to basically adjust status. But other than that, those are the only way. Okay, so if you need a consultation for something unrelated to this, or you just want a deep understanding, again, you can schedule your consultation by using the link in the description box below. Until next time, bye-bye.